It's stuck. I think that's a sure signal that it's recording. Well, good morning, everybody. How are you?
Good morning.
So we have a number of new laws that are affecting us, unfortunately. And I thought we would go over that now instead of waiting till it's too late. So let's start with advertising, digitally altered images. A real estate broker, salesperson, or person acting on their behalf who includes a digitally altered image in an advertisement or other promotional material for the sale of real property shall include in the advertisement or promotional material a statement disclosing that the image has been altered and a link to a publicly accessible internet website. Shoot, I'm just trying to read off.
Followed you, but it lost you.
You think so? All right.
Yeah.
Sorry.
So we got luck.
Running after me.
It's looking for you over there.
Thank you. It's blinking blue. With your thumb, please. There we go. Okay. Everybody hear me now? See me now? Yes. Perfect. So with that said, let's continue on. The statement, there has to be, so if you digitally alter a picture, now you have to disclose that fact. You need to provide a link to the original picture, or you need to show the original picture to show exactly what it is you're portraying. Now, I've witnessed things like this in our office. We made pictures look better. It doesn't include cropping, things like that, or enhancing the brightness.
Some people add grass in the front yard when there's no grass.
Yeah, and that was me that said, let's do it. So, and it looked a lot better, and that property was sold right away. It wasn't because of me. But if the advertisement is posted on an internet website over which the broker or salesperson or person acting on their behalf has control, they may alternately include the unaltered version of the image. So this law applies to images altered with photo editing software or AI, but does not apply only when common photo editing adjustments are made, and I'll go through that. So it requires that a digitally altered image used in an advertisement or other promotional materials for the sale of real estate includes a reasonably conspicuous statement located on or near the image stating that the image has been digitally altered, a link to a publicly accessible internet site URL or QR code in which the original image is clearly identified, and the statement must also indicate that the unaltered image can be accessed at the link URL, so on and so forth. So if it's posted by the broker or the agent, you may comply by either including the unaltered image in the posting or by including the link to the original photo, as a matter of fact. So digitally altered means an image created by or at the direction of the real estate broker or salesperson or person acting on their behalf, altered by photo editing software or artificial intelligence to add, remove, or change elements in the image. And this is what is going to be helpful to understand that, including fixtures, furniture, appliances, flooring, walls, paint, color, hardscape, landscape, facade, floor plans, and elements outside of or visible from the property, including but not limited to street lights, utility poles, views through windows, and neighboring properties. So that's very conclusive, as a matter of fact. You can't eliminate wires, street poles, when you add furniture to a property, or you remove utility boxes in the front yard. You must somehow include a reference to the original photograph, as a matter of fact.
I wonder how the MLS is going to accommodate that.
This is not the MLS. This is California law. Now, how the MLS is going to accommodate, that's a good question. How we're going to do that. You may have to remember, you can actually put comments beneath photographs on the MLS. So maybe that's one way of addressing that. Maybe posting pictures on the MLS that are altered
The
is
before
going
and
to be
after
an
shot,
issue.
like the before and after shot, like
I guess you could
side
do
by side.
something like that, right? You could do something like that.
So you're basically doing the virtual staging thing.
Yeah, virtual staging is going to require a disclaimer and a picture of the actual property without virtual staging.
The green lawn is no longer green.
A green lawn that's no longer green, exactly, right? It's burned out, right? It looks good in the one photo, but the other side is its reality. So I can just imagine there's going to be a number of agents who are going to be telling on somebody, right, reporting to the Department of Real Estate that, look, they never did post the actual photograph depicting the property in the actual condition. So cropping, that's okay. Enhancing the brightness, that's perfectly acceptable. And also this applies to leases in excess of 1 year duration. So not just properties for sale. And then this is something that was postponed, but building or balcony inspections. If the property consists of 3 or more units, and this was effective actually January 1st of 2025, but it's been delayed until January 1st of 2026, all of the balconies must be inspected. So that's something that's still forthcoming for anybody that has multifamily unit properties, so 3 or more units, as a matter of fact. But the change is going to be if during the inspection or if there are modifications required to the balcony and there is asbestos containing material associated with that, you're going to be granted another 9-month duration of time before you have to comply with the actual report. But so you wonder when we're inspecting balconies, if it's fine, there's no remediation required, then anything associated with asbestos, assuming it's not going to be disturbed in any way, is not going to be an issue. However, if there's any repairs required, and that requires disturbing the asbestos, now that's going to require somebody who's licensed to address that. You have a 9-month duration of time to comply with that, and 3 months thereafter to provide the actual report for the balcony inspections. So any clients of yours that have properties with 3 or more units and there's a balcony, they have to have those properties inspected by January 1st of this year.
Whether they're being sold or not.
Whether they're being sold or not, exactly. Because that report has to be provided to any subsequent buyer. Plus, you're going to have to be prepared as a property owner to have that available for the state of California. So that's very unfortunate, as a matter of fact. It's hard to believe we have to do all these things. And then this is probably more likely to the 16 or 17,000 units that were burned near Malibu, as a matter of fact. But the new law prohibits buyers from making unsolicited offers on residential property in fire-affected zip codes. So if you have clients that are interested in buying property and the property is not listed in a traditional manner, for example, and they solicit or you solicit a person whose home has been destroyed, you're going to be in violation of the law for the next year, as a matter of fact. And there are specified zip codes of which this is associated with.
Well, you got to give them first dibs, right?
Yeah. If somebody's aggressive in regards to making an offer to somebody who's distressed, I don't know if that's bad or good, right?
Yeah.
Maybe that's their way to get out of it, because I can't imagine how many years it's going to take to rebuild that area that's been affected by that disaster.
Sure, the government wants to buy it up first.
Yeah, that's very possible. The government may want that property, as a matter of fact. So in the event someone were to enter into a purchase contract in a fire-affected zone, for example, they have a 4-month right of rescission after the close of escrow if this law had been violated. So that would have detrimental consequences, I would say, when doing something like that. Has anybody here had anybody who's had a client that's interested in contacting property owners in these fire-affected zones? No? Okay. And if you do, you don't want to make an unsolicited offer, because it is also going to be a violation of the law for you, for the buyer, so on and so forth. So, but if the seller is putting for sale sign up, if you're an agent and you just want to contact somebody saying, would you like to list your property? that's not an unsolicited offer.
Oh, it's not.
It's not.
I thought that
It's
was
not.
also included.
No, if you're calling them and saying, I've got a buyer that's wanting to buy your property, or you're trying to buy the property, then that would be a solicited offer and would be a violation of the law. So that's in effect right now, as a matter of fact. Let's keep that in mind.
Are there any additional inspections that need to be conducted before the sale of those properties?
I would think environmental hazards is something that's every homeowner or property owner is gonna have to overcome when reconstructing. And I would think that's gonna be part of the entitlement process. Because who knows what's lying in the ground after the fires have occurred. That's a good question. But yeah, I would say it's gonna be a very difficult process for anybody that's going to be developing or reconstructing the properties in those areas. And then defensible space. The State Board of Forestry and Fire Protection is required to adopt regulations to implement defensible space requirements for an ember-resistant zone required within 5 feet of a structure. So right now, there are no requirements for fire-resistant areas within 5 feet of the structure. Regulations are going to be coming out that now are going to state, and who knows exactly what that's going to consist of, but maybe you can't have any type of foliage right next to the house. And a lot of people tend to do something like that, right? So that's something that we're going to be facing here, as a matter of fact. And so 5 feet is obviously very, very close, but it requires the State Board of Forestry and Fire Protection to adopt regulations to implement the Zone Zero defensible regulations. There is no zone zero currently at this point in time. So in the next year, we're going to be seeing regulations for existing properties, and there's a 3-year duration of time thereafter for somebody with an existing property to comply with those guidelines. But for new construction, they'll have to comply with it at the time of sale of the property.
That's anywhere in California?
I would say that's going to be anywhere in California. Right, these are state laws. Right. So if you have clients that are going to be installing softscape landscaping directly next to their house, you might suggest to them, in 3 years from now, approximately, you may not be meeting the stringent Zone Zero guidelines, as a matter of fact. And we don't know what those are yet. So they're going to be forthcoming, but it doesn't matter, because it doesn't matter how much it costs a homeowner to comply with those regulations. And it very well could become a point of sale requirement, as a matter of fact. And then balcony inspections, HOAs are required to now include in the HOA documentation information associated with the inspection of balconies. So that's something that I think that we should all be aware of. And why is it important to us? As lenders now may be looking at, and that could be a cause for a failure of a transaction. So when we get the HOA documentation, we don't know exactly what the lender is going to be looking for, but we should be looking to see whether or not the balconies meet the current requirements. And the problem is, in many cases, the HOAs are not actually performing or having the inspections performed. So a lender very well may make that requirement. But it's something for us to look at, as a matter of fact. Just want you to be aware of that. And then third-hand smoke residue and disclosures. It is the sole responsibility of sellers to disclose actual knowledge of any residue from smoking tobacco or nicotine products in residential real estate sales, or any history of occupants smoking tobacco or nicotine products on the property. So it's interesting. It doesn't include marijuana. So I don't know. I think that you may have to disclose that also.
That's what I was thinking.
I could hear you chuckling over there. So residue from smoking tobacco means the chemical accumulation left behind from smoking tobacco or nicotine products. It accumulates in carpets, walls, and furniture, becomes embedded in building materials, and persists for years after smoking stops. So smoking tobacco includes the use of an electronic cigarette or vape device. So now this is going to apply to transfer disclosure statement requirements, as a matter of fact. And with a transfer disclosure statement, because we're probably going to see this as an amendment to the seller property questionnaire. Remember, if a transfer disclosure statement is required, the seller is also required to provide a seller property questionnaire. If a TDS exemption exists, than an exempt seller disclosure. It'll be interesting to see if the exempt seller disclosure is modified to accommodate that. But it's because the SPQ is required, if the TDS is required, there's going to be a modification to the seller property questionnaire in which those questions are asked. So I think it's important when you look through these seller disclosures, because you should be helping your clients if they're aware of, or maybe they bought a house and somebody previously disclosed that there was smoking on the property, be sure they're disclosing that properly. So remember, with that said, because it is going to be a disclosure associated with the transfer disclosure statement, remember, upon delivery of the transfer disclosure statement and or seller property questionnaire, there's a right of rescission. So if it's delivered personally, 3-day right of rescission, electronically, a 5-day right of rescission. And that's true whether or not the buyer has removed all contingencies.
So this has to be disclosed beginning January 1st?
Yes, we should, well, I would expect to see modifications to the forms in which there's going to be information associated with smoking or secondhand smoke, as a matter of fact. I think the question already exists in regards to smoking on the property in the seller property questionnaire, but I think it's going to be much more detailed in regards to what the questions are. But it surprised me now that they're including vaping also. And I see people vaping, but I don't know if it has the same effect as someone smoking a cigarette, but apparently it does. Permeates the walls.
Does it include outside the house, in the yard?
I
or
would
is
think
it
that
just-
any smoking on the premises, outside or inside, is probably, if I'm filling out my disclosures, I'm going to say that there was smoking if somebody's outside, you know, because it can drift inside. Now, unfortunately, it's never that clear, but if you want to be consistent or at least be careful, I would think that that's something you would say, yes.
Yeah, and they can specify only outside.
Yeah,
or
you can
whatever,
say
you know.
outside if you know that, right?
Yeah.
You know, we don't know that if you have tenants in a property and they claim they're only smoking outside because you said no smoking and no smoking on the premises, do we really know?
Yeah.
I'd rather just say yes and then qualified saying unknown, you know, tenant smoked. We don't know if they smoked inside or outside of the property, but at least putting them on notice is probably a good idea. And then something that's very critical, as a matter of fact, can you pull up that form that I had on?
You said marijuana is not included.
Right now, it's not. They didn't include that in the definition in regards to the transfer disclosure statement disclosures. Pretty interesting.
Weird.
Isn't it? Any kind of smoking, it seems
Yeah.
like it would be probably wise to disclose it. You might just say smoking. If somebody's smoking pot in the house, you might just say, yeah, there's smoking in the house. I don't know if you have to go into details on that, but if you think that somebody's been smoking pot in the house. So the form that's currently on the screen, that's new to the RPA package. Any purchase contract within Zip Forms now has this form. And this is going to be a real burden for people, as a matter of fact. So initially, implementation was scheduled for December 1st, but it's been postponed until March 1st. But this is something I think we need to really go through in detail. So beginning March 1st of 2026, any escrow title company responsible for closing must submit reports to the Financial Crimes Enforcement Network, also known as FinCEN, if all of the following apply. It's a residential 1 to 4 real estate property. If it's purchased, so vacant land, depending upon the intended construction. The buyer is a legal entity or trust, and the transaction is all cash or being financed with certain lenders. If it's a lender, let's assume it's Bank of America, they're federally insured. They're going to be reporting appropriately to FinCEN, as a matter of fact. But it's anyone that's making an all cash transaction, or they're getting funds from alternative sources other than a traditional federally insured bank. These requirements are going to have to be met. So in that case, legal names, dates of birth, addresses, DBAs, citizenship, and taxpayer identification numbers of the buyers and sellers and their entities must be obtained and reported to FinCEN. Without this information provided, the escrow will not close. So we're going to have a lot of disgruntled buyers and or sellers. They're involved in a cash transaction. They think, oh, this is great. I've got an entity that's making an all cash offer. That's already a flag. So it's now going to require both the buyer and seller to report all of the underlying information. So if it's an LLC, and maybe the LLC has individuals that are members of the LLC, but the members can also consist of other entities within an LLC. So all of the underlying individuals are going to have to provide all this information. It's not just the buyers, but the sellers also. And then we keep hearing about these transactions in which there's monies being transferred is it yuan? What form of currency is it? Outside of the country. All of this is going to be reported. And I think that the whole purpose of this law is to prevent money laundering.
Well, also, one of my buddies was was going to bid on a house that was up for auction that was seized from a cartel member that owned 21 homes that were seized. So
There you
that's another reason.
I have
Yeah.
questions.
Yeah.
So for the cash buyer, do I need to have the tax ID before they purchase it?
Well, they just need to be made aware. And Mary, you're probably hearing this at Lawyer's Title also in regards to how we're going to apply this. That's going to be another issue, but
Yeah.
they're going to be asking for the tax IDs of any buyer and or seller. Absolutely.
So we have to encourage our buyers to get the tax ID before they purchase. No,
Well,
before
if
they-
it's a buyer, now remember, you can still buy a property in the US without a tax ID, but that's going to be more applicable to a seller in regards to the withholding aspects. If they don't have a tax ID, they don't have a tax ID.
I thought you for the next year they still require to.
No, I don't think it's a requirement. It's if you have one.
If you
have
have one, you need to
disclose it.
provide that
Right,
information.
we need as much, we're told that we need to collect as much information as possible on that
Yeah.
person.
So, but it's not the, in fact, to delay the close.
Here's what I'm going to suggest. If they don't have a tax ID, you've made the request, but they provided all the other information that's being requested, then I would think the transaction could close because there's nothing in the guidelines that suggests that the transaction cannot close. But if there's non-compliance by the parties, then they would just have to indicate, for example, I don't have a taxpayer ID. Likewise with the seller, if they don't have a taxpayer ID, they need to disclose that, and there would be backup withholding for both federal government and the state government. So any transaction in which a seller, remember, closes a transaction, don't have a tax ID, they're subject to withholding. So as much as 15% for federal and 3 to 3% of the selling price for the franchise tax board. I just think it's going to be very uncomfortable for most people, and they think I'm involved in it in an all cash transaction. Now, me, the seller, why do I have to provide all this information to the government? Well, it's just because it's going to be the law now.
Thanks.
What is the impact of that on real estate? Because I think this is a good law. I'm glad finally they came up with it after a few years. Because a lot of money from overseas have been coming and they just buying cash and stuff. So it prevents that kind of a transaction if the money's.
I think that's exactly part of the intent, as a matter of fact, to make it a more level playing field for people here that are trying to buy real
Exactly.
estate. So maybe a little less competition as opposed to somebody that's trying to launder money through real estate
Which
transactions.
has
So,
been going on last 10, 15 years.
yeah,
Extremely.
yeah. It's
Yeah.
just gotten
Okay.
worse, as a matter of fact. So it just, let's face it, we know, we go through this all the time now. If there are individuals that don't have taxpayer IDs or they're trying to circumvent withholding, it is a constant problem when we're managing transactions in the escrow side of it, as a matter of fact. Nobody wants to have a couple of $100,000 of their sales proceeds for their seller withheld from the sale. So they're always very unhappy about that. So this is even going to make it more difficult for people to hide money. And then for buyers that are trying to launder money, it's going to be much more difficult now because that has to, right now, within the inception of a transaction or within 7 days of execution of a transaction, the parties are going to have the obligation to provide this information to the reporting entity.
This is effective March 1st.
It is March 1st, yes. It was scheduled for December 1st, but it's been postponed.
It could be postponed again. I think.
Well, anything's
Let
possible in the
people
federal
do
government.
Whatever they need to do.
Yeah, and
to
it's,
clean their books.
yeah, it's it
Oh,
very well
shoot.
could be postponed once again, as a matter of fact. So once again, when is the reporting requirement? If it's residential 1 to 4 units, the buyer is a legal entity or trust, and the buyer's making an all cash purchase or financing the purchase through a bank, or other institution that does not have an independent money laundering reporting obligations. And there's a few exemptions, as a matter of fact. So if, let's assume you're transferring a property into your own revocable trust, that's exempt from the reporting requirements. But the obligation for giving all of the underlying information is imposed on both the buyer and the seller, so keep that in mind. So information that's going to be collected, I want to go through this again: legal names, dates of birth, dates of execution of trusts, addresses, DBAs, citizenship for trustees or beneficial owners of trust buyers, and taxpayer ID numbers, and if applicable, the account number and financial institution name from which the payment is made. Pretty inclusive in regards to all the information that's going to be collected in this transaction. What was that, Schmidt?
TMI.
It is. It's too much information. More government intervention, isn't it? So remember, they have to deliver this information within 7 days. And what do you do if they don't deliver it? Well, you can send them a notice of reform and cancel the transaction, because the reporting person, the escrow and or title company, is not going to close the transaction unless the requirements are met. So it'll be interesting if there's no taxpayer ID and I say I don't have a taxpayer ID. Well, it's probably met the standard, as a matter of fact. I don't know exactly what these forms are going to consist of in regards to the collection of information, but it's going to be very far reaching.
It's
And-
7 days within opening of escrow.
Pardon me?
The-
Within 7 days of contract acceptance. So the form already is a part of the RPA package or any other purchase agreement found in zip forms. And I thought I would put that up here on the screen for everybody to see. This is something that people are saying. In addition to that, even though the requirement goes into effect as of March 1st, if for some reason there's a thought, even though the scheduled close of escrow is to take place before March 1st, if for any reason there's belief from the reporting person, namely escrow and or title, that it's going to fall beyond March 1st, on March 1st or beyond that, then they have an obligation to collect this information.
We thought SIs were hard. Wait till this comes.
This is going to be hard. Yeah, it's going to be very interesting to see how this is implemented and the compliance aspects of this and who's going to be responsible. So I think everybody from the closing side of the transaction, escrow and or title, they're going to be very nervous about breaking the law or making sure that they collect this information in advance of closing a transaction.
All this law makes selling their home much harder.
It does. It makes it
People,
very
it
hard.
scares people, they want to stay put, so it's not good
Mhm.
from that perspective.
Yeah,
Is this just California or is it a federal law?
I would say that that's going to be, I'm guessing that's a
This is
federal law.
federal,
I
okay.
understand that, yeah,
Okay.
but because now we're talking about FinCEN, it's not just a California change, but it's going to be nationwide, as a matter of fact. So transactions that are exempt, so transfer that is a grant transfer or revocation of an easement, so giving up an easement. Transfer resulting from the death of an individual, whether pursuant to the terms of a will, the terms of a trust, the operation of law. A transfer incident to divorce, so you're getting a divorce and one spouse is transferring their interest to the other spouse. And a transfer made to a bankruptcy estate, a transfer supervised by a court in the US. And this is interesting, a transfer to a qualified intermediary for the purposes of a like-kind exchange. But my guess is once the exchange takes place, then whomever the accommodator is and or the closing entity of the reporting person is going to require to collect all the information at that point in time. And then the other thing, keep in mind in regards to like-kind exchanges, I just thought I would bring this up. But sometimes people think that I'm the seller and I don't have a taxpayer ID, and the sale of my property is subject to withholding for as much as 15% of the gross sales price for federal purposes and 3 1/3% for the state. But if I'm engaging in a 1031 exchange, I can avoid the withholding. Is that true? It is not true. There's virtually no way to avoid that unless you have a taxpayer ID. But those are questions that come up all the time. Well, I'm doing a 1031 exchange. Well, that it just doesn't matter, as a matter of fact.
Well, they tie it to your social security number, right, for when you do have to pay taxes.
Well, if you don't
'Cause you're
have
deferring it.
right, if you don't have a social security number, right, then what takes place is the withholding entity is now going to submit that information on Form 8288 to the Franchise Tax Board and or the IRS, and they're going to identify the address of the property. So the person who's selling the property, they can recover those withholdings if they file a tax return. And they would identify the property address itself. But there is no taxpayer ID, unfortunately. It seems like, well, there is none, obviously. That's why withholding takes place. HOA fines are going to be limited to $100 per violation for health and safety reasons. I'm not sure what the health and safety reason is. And that's, as a matter of fact, there are exceptions. If it's a health and safety violation, it could be more than that. But of course, the guidelines don't define that well enough. So there's a lot of opposition to that. But I think there's good and bad things about limiting the fine to $100. Before, that was probably the HOA's only methodology of forcing compliance with somebody. But now it can be no more than $100 fine for a violation.
Are you looking
For health reasons,
Yeah.
for mental health reasons.
Yeah. And then the California Fair Plan. Remember, if you can't get insurance for homes through traditional means, you can go to the California Fair Plan, as a matter of fact. And here's something I just thought was of interest. It certainly is to me. So now the California Fair Plan can issue debt obligations to finance premiums or any payouts. So now they may not be collecting enough money to cover the claims in which they're obligated to pay. Now they're going to be issuing debt obligations. They're going to be borrowing money to pay claims. There's just, the whole insurance industry is just broken in California. It's probably broken in the entire country, but I think because of the ability of people to sue here so easily, that is part of the reason that insurance premiums are as high as they are, and the Fair Plan exists. But that's scary to me. We're going to be borrowing money for this entity to pay claims. That's what's going to be happening.
So we're paying twice the
What,
tax.
can you explain that again? I'm sorry. Can
So
you
the
explain-
California Fair Plan, usually insurers, they collect insurance premiums, and from that, then they pay out claims.
Right,
Now, California Fair Plan, something that our government provides. If you can't get insurance through traditional means or State Farm, for example, you can go to the California Fair Plan and get homeowners insurance. But now they're running out of money. Now, to pay those claims, they're going to be borrowing money.
oh my,
Yeah, yeah.
Who are they gonna be borrowing money from?
From our taxes.
Investors. You want to get, you can maybe, I don't know what they're going to be paying investors. Maybe it's 4, 5, 10% in regards to borrow money, right? Like bonds. Yeah. So they're going to be borrowing money to pay those claims out.
So they're not
Instead of
taking
just
from
adjusting the
taxes.
premiums to adjust that, or maybe we should amend the guidelines in the state of California in regards to what the payment of claims is going to consist of.
this is just in California, right?
Mhm.
Who wants to live here? Nobody.
There's a lot of people leaving, yeah. And then, of course, there's always more associated with landlords. So electronic return of security deposits. So electronic return of security deposits is a default option when the initial deposit was made electronically unless otherwise agreed to in writing. So upon termination of a tenancy, the landlord must send notice of the right to receive the security deposit electronically if paid electronically, unless otherwise agreed to in writing. However, return of itemization of the deposit is via mail by default, unless the landlord and tenant agree to an address or email address provided by the tenant. And then when there are multiple tenants, the security deposit will be returned by check made out to all tenants unless otherwise agreed in writing. So I would assume that we're going to see a change to the residential lease agreement. And in the event a buyer or tenant makes an electronic deposit initially at lease inception, now it's probably going to state that the return of that money will be done electronically unless the parties agree to another form, for example, writing a check. So it could come down to the fact if you have multiple individuals on the lease, the landlord may have to make multiple electronic payments to all these different individuals. Or if they just write a check when writing a check, you should be specifying every single party who's named in that lease in that check. It would be a joint check. Richard Moore and Carlos Rodriguez, if they were rooming in that apartment together.
Who wants to rent?
Well, there's more reasons to not be an investor in real estate in
Exactly.
California. So the parties can designate a different method in regards to how that monies can be returned, as a matter of fact. Yeah, exactly. It's just looking through the details here. And then you can amend that, right? But the parties have to agree to amend that in writing, as a matter of fact. And right now, remember, in regards to the obligation of a landlord to not just returning the balance of the security deposit, if any, but notification of the balance that's due to the tenant. There's a 21-day time frame following the date in which the tenant vacates the property to give an accounting of the security deposit and or return the balance of the money. So right now, it's still required that you do that in writing via first-class mail. Now, if you agree electronically, you can possibly return or give an itemization via email, but the parties have to agree to that. And that, I think, is much preferred from my perspective. Because even when sending something via first-class mail, someone can contest that all day long. So I would never suggest returning anything via first-class mail. You'd want at least registered mail to document the fact that you put something in the mail. And then also the itemized statement, the landlord can choose to whom anyone they deliver that itemized statement as to the disposition of the security deposit. You can do that. Or if there are multiple tenants, they can all the parties can agree to which tenant the deposit would be returned in the event of termination. But at this point in time, unless there's something in writing, then the best practice is to write a check directly to all the tenants named on the lease. And that's going to apply to any successor in interest, meaning if that investment property is sold, the person who bought that property as an investor is going to have the same obligation. And let's see, what else do we have?
It seems like a revolution in the real estate law, right? Every 10, 20 years, I guess we go through this.
Oh,
Is
well,
that
I think
true,
it's just getting
Richard?
worse. I never see anything that gets better for investors. It doesn't seem that way. And then not that this probably applies to most of our clients, if any of our clients, but the law also prohibits a property owner from requiring a tenant to use a specific internet provider. It's probably more likely with large rental apartment buildings, I would think, as a matter of fact. And then safe maximum indoor temperature declares that the established policy of the state is that all rental dwelling units must be able to maintain a safe maximum indoor temperature beginning January 1st, 2027. Various state agencies must consider this policy when revising or establishing regulations. So talk about something that is completely undefined.
Right.
What is a maximum safe indoor temperature that a building can actually maintain? So that's coming also January 1st. Shweta, I'm glad you're enjoying this today.
It's just not right for Goldilocks.
Yeah, it's just crazy. And then this is something that's affecting every single landlord, as a matter of fact. Requires a landlord to provide both a stove and a refrigerator maintained in good working order as a condition of habitability. The tenant may choose to provide their own refrigerator by mutual agreement when the lease is signed. So if the tenant wishes to provide their own refrigerator, they can do so. However, and the landlord's not responsible for maintaining the refrigerator and the stove, that's been a foregone conclusion. But now, if the tenant does not provide their own refrigerator or do so in writing, the landlord has an obligation to provide a refrigerator.
What?
And must be maintained in good working order. No, it's a refrigerator, not a what?
Isn't that the case?
Refrigerator, but like normally, if there's no refrigerator rental unit, the tenants always bring their own.
Yeah, well, not anymore. They won't have an obligation to, and you cannot make them bringing their own refrigerator or not supplying a refrigerator as a precondition of renting the property. I see a hand.
So for existing lease, if make a thing then saying that landlord doesn't wanna maintain after the refrigerator is broken. After next year, then you know.
We won't, that's not going to be enforceable. If the landlord says, I'm not going to maintain the refrigerator.
Washer dryer, they don't need to make.
Not yet. That's probably coming
Not
also,
yet.
all right? So washer and dryer now.
I'm sure that they're gonna add that too.
Yeah, eventually, right, exactly. Let's freeze next, right? Let's move to New York.
So basically, it's pro-tenant laws, really.
Yes, it is, as a matter of fact. That's exactly what's taking place. But now, rents are gonna go up. That would be my opinion if I'm a landlord. If I have to do all these things and I'm not doing it, I'm going to increase my rents. And I would think that we're gonna probably see the same thing in the aspects of many other investors. As a matter of fact, they're gonna say, okay, we're gonna do that. I'm gonna have to charge for that because they can't afford to do this otherwise.
When does this start?
January 1st.
January 1st?
And then they're gonna put a cap on that, restrictions on that.
January 1st
Rental
of this
increase.
year or next year?
This coming year. This coming year. Yes, yeah, this is going to be this year, as a matter of fact. So if it's a month-to-month tenancy, there's an exemption that if none of the terms of the tenancy change, then they don't have to do it. But if there's a change in regards to if you increase the rental rate, for example, in a month-to-month tenancy, if there's a change in terms, then the landlord's going to be obligated to offer a refrigerator if they're not doing so already. Isn't that great?
Mhm.
Yeah, personal property, that's
Good stuff.
and then if a tenant cannot pay their rent due to an interruption in the payment of social security benefits, that's a reason to postpone or delay an unlawful detainer action. So, and it could be applicable simply because the government shut down now, I don't know.
Yeah.
I don't know if they stop paying social security benefits at this point in time. As a matter of fact, I don't know that. I don't think that has happened, but if it does happen, that's a reason to invalidate an unlawful detainer action. And then this is worse, getting worse for landlords, as a matter of fact, service of process substituted service. So there are additional procedural requirements for substituted service, meaning my tenant isn't paying, I'm going to serve them with an unlawful detainer action. So now the requirements for service of process has been increased, as a matter of fact. So let me go through the details of this. So the party has to show reasonable diligence by attempting personal delivery of the summons and complaint in good faith on at least 3 occasions on 3 days at 3 different times. That at least one of the attempts must have been made at the house or usual place of abode of the person to be served. Now this is where it gets worse. Photographs. Requires that proof of service of summons must include 1 or more photographs of the site of each affected or attempted service. Each photograph shall contain a readable stamp indicating the date, time, and global positioning system coordinates of the service or attempted service, or declaration of process server if no GPS, cellular, or equivalent signal is available at the time or place of an affected or attempted service.
I wonder if the metadata on the picture itself is sufficient.
And that's not what this is saying. But this is going to be like a spy movie, right? You know, where
Yeah.
they track somebody with the cell towers. So they're going to have to provide that information. Why am I saying going through this is we're not going to be a process server. However, I think this is even a better reason when you're evaluating tenants to increase your scrutiny on any potential tenant. You don't want to get into something like this because once they stop paying, they're smart enough to know to avoid service. It's going to take a long time. We think it's hard enough now to get people out of a property if they're evicting them. And then actually, if for some reason they have any evidence whatsoever, they can actually submit a motion to vacate the unlawful detainer action to a judge. So yeah, it's going to be even harder to get somebody out. So here's some of the opposition. So this is saying requires 3 separate service attempts, mandates at least 1 attempt at a home address, even when the petitioner has not provided one. The sheriff's office serves only, the sheriff's offices serve only at the address provided. They cannot verify or determine whether it is a home address. GPS stamped photos would demand new cameras, printers, storage, and staff time. Proofs of service already carry a sworn deputy's signature under penalty of perjury. Deputies' body-worn cameras already provide geotagging and accountability, but that may not be permitted, as a matter of fact. And then, of course, it's going to be taking more time from, I would say, the people that protect us, because
Yeah.
they're going to be spending more and more time on things like this. So those are the things that are happening as of the beginning of the year. And of course, the compliance with FinCEN is going to be effective March 1st, unless it could be applicable even sooner. For some reason, it's anticipated a transaction could close before March 1st. And I don't know what the documentation is going to look like or how we're going to be requesting that information from parties. We see a lot of all cash transactions in this office, especially from entities. So it's going to put a lot of people in a position that they're going to provide information that they never have in the past. And that's what their comment's going to be. I never did this before. Well, that's the way it is, right? But you're going to have an obligation to do it now. Otherwise, the transaction is not going to close. And they're going to be looking at us. So, any questions about that today? No? Okay. So I would assume that we'll have form changes. We'll go over that before the first of the year, so everybody is apprised of what's taking place, so we can address that as we should. All right. Well, thanks for coming, everybody, and for those of you that came last Friday, thank you. That was a lot of fun. Had a great time. If you want to see the pictures, I think we have them on our web on Facebook, right?
Or they will be.
For Halloween, or they will be. Well, thanks for coming, everybody.
I have a
Thank you.
question.
Yes, what's that?
What about the requirement for garage? I heard that there was some kind of a modification to the zoning in California for each city, that you don't have to have garages if you live within certain distance to a transit station.
It's
or
true,
bus
and there are
stop.
certain designated zip codes in which developers can construct units and not provide parking, but they have to be within, there has to be, I think,
half a mile or something.
pardon me, it has to be close to within 15 different areas of public provided transportation. And there are zip codes that are published, as a matter of fact, in which that's applicable for somebody if they wish to develop residential housing.
What about the existing homes? If they are within certain distance, the buses stop. or
They
something.
very well may not have to provide a garage. I don't know if they're going to have to, but I think it's more geared towards new construction to encourage the development of new construction, because we keep
To
hearing that
build
there's
by
a,
the transit station.
yeah, we keep hearing there's a shortage of housing in California.
Do you know where I can find that information?
Yes,
Okay.
I'm a wealth of information here. I can send that to you.
No, I mean,
On CAR's website, for example,
oh, okay.
yes, you can find that.
Okay.
Under risk management, there's a tab called risk management. So yes, that's
I was
available.
wondering if people can convert it, you know how people have converted their garages to living space, right?
Yeah,
We have heard of that last few years, especially last 4 or 5 years. So then garage becomes a living space, and if it's a single detached, then it's hard to find.
yeah, I don't think that's what this is geared towards. I think it's just constructing multifamily housing in an areas where it doesn't exist currently, and not having to meet the parking restrictions where converting a garage into a single family home. I
It
don't think
doesn't
it's going to
apply
fall
to-
into the same guidelines
I
here.
see.
You probably need a permit though, right? To convert the garage into. like-
Yes.
Ideally, yes.
Yes, we
Yeah,
do.
yeah, yeah. Yeah, well, you can call it an ADU, and there are virtually no restrictions on ADUs. It's very nominal, as a matter of fact. It's easily done. Of course, Shweta hit me yesterday with Senate Bill 9, which is splitting a lot and then building or maybe selling that lot. There's properties in Garden Grove or Santa Ana, as a matter of fact. You know, implications with that, if you have a loan on the property, for example, you're going to have to get a partial release from the lender, and her client actually has a loan on the property. And then the duration of time to go through the entitlement process, that's going to take a long time, I'd say. But you put a ADU on the property.
I gave him all the negative aspects of not.
And what did he
doing it.
say?
He said, oh, I will have to really consider that. I said, yeah. let's do it."
Yeah. I think just to get a partial reconveyance from a lender in regards to a lot split is going to be a task in itself. As a matter
And I
of
was
fact.
like, please talk to your contractor, check it with the city, and then also talk to your lender. Once you've done that, you kind of get a time frame, but most likely 2 years. And then you're probably looking into making another 200 extra on it, but then we don't know how the market is gonna be.
Yeah. Well, good. You got out of
Yeah,
that one.
exactly.
I think, and part of the problem for her was just coming up with a value of that property. If there aren't that many, we're seeing lot splits, as a matter of fact. How do you place a value on that if you don't have any of the comparables?
So, don't forget to RSVP for the Christmas party, everybody.
Oh, yeah, you don't want to miss that.
It's gonna come so fast. I mean, it'll be here in no time.
Also, tomorrow, the landlord here is having an ice cream truck coming in front, so they'll have free ice cream between like 1:30 and 3. So if you're in the office, they'll come in here and tell you. So if you want some free ice cream sandwiches or whatever they